Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our lecture number 57. And we are going to deal with a very important topic with respect to the leading cases. See, as far as the Advocate on Record examination is concerned, you all know that there are 4 subjects. In one of the subjects, that is leading cases, the Honorable Supreme Court has prescribed almost 86 leading cases. Very, very important landmark judgments where the Honorable Supreme Court has laid down the principles, settled the proposition of law. So, in order to avoid conflicting decisions among the high courts in the country, to have more clarity for the litigants. So, therefore, these landmark judgments, though there are many landmark judgments, but as far as the examination is concerned, we have got 86 landmark judgments, out of which we have covered from 86 to 84. Now we are going to touch upon the serial number 83 of the revised leading cases. The name of the leading case is State of Punjab versus Davinder Singh. I repeat, State of Punjab and others versus Davinder Singh and others. The matter is decided, this landmark judgment is decided by 7 judges bench. So before dealing with the topic, it is our regular practice that we recite the preamble of the Constitution of India. Why should we recite preamble for every session? It is like asking question, why should we have breakfast, lunch and dinner? To lead a life, we need nutrition, we need minerals, we need protein, vitamins. Similarly, for the healthy nation, to make a nation wealthy, prosperous, so it is our duty to remind ourselves that what was the aim of our founding fathers and founding mothers while drafting the Constitution of India. So though it is running to several provisions, but what is the essence of the Constitution of India is, it is being reflected in the preamble of the Constitution of India. See, every statutes must be obedient to the Constitution of India. If statutes are not obedient or inconsistent with that of the Constitution provisions, then Supreme Court or High Court can struck down. And then Constitution provisions, their aim is to achieve the goals enshrined in the preamble. That is why one of the celebrated judges, Honorable Justice Krishna Iyer, whenever he wrote the landmark judgments or any judgment that he wrote, it became a landmark judgment. He always had preamble opened before him, and he always used to write to what extent we can connect the preamble to the judgment. In one of the cases, Honorable Justice dealt with company law, company matters, where lordships brought economic justice. It is there, justice, social justice, economic and political justice. When there is a reservation question, social justice. When it talks about right to livelihood, it becomes Article 21, right to livelihood. So therefore, dear friends, preamble is like our soul and it is our goal. So with this sentiment and commitment, let us recite the preamble. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. Now let us move on to this topic, State of Punjab versus Davinder Singh. It is reported in 2025, Volume 1, Supreme Court Cases, page number 1. 2025, Volume 1, Supreme Court Cases, page number 1. I am going to deal this topic under few headings. Firstly, facts of the case. We should understand what is the origin of the case, facts of the case, number 1. Number 2, what are the issues involved? What are the issues involved? Number 3, how the matter reached the larger bench, 7 judges bench. This matter has been decided by the 7 judges bench. How the matter has reached. Number 4, what are the decision given by the honorable judges? And thereafter, reasons to their decision. Today, I have planned to deal only with the majority of the judgment. It is 6:1. 6 majority and 1 dissenting judgment. So, majority authored by Honorable Chief Justice of India, the then Dr. D.Y. Chandrachud, on his behalf and on behalf of his learned brother judge. The remaining other judges has concurred with the Chief Justice, but they have given their own independent opinions also. So this is what we are going to discuss today. And minority judgment, dissenting judgment given by Her Ladyship Justice Honorable Justice Bella M. Trivedi, Her Ladyship, minority decision will be dealt in the next session. Right? Now let us understand the facts of the case, dear friends. And keep the preamble before you. We are talking about social justice. This case entirely revolves around the social justice. How the backward persons, how the scheduled caste, how they can be brought into the mainstream. Therefore, they get the due representation and they can also lead a meaningful life, a dignified life, social justice. Now, let us understand the facts of the case. In state of Punjab, the name itself indicates state of Punjab versus Davinder Singh. State of Punjab has enacted a law. What is the name of the act? Please note down, dear friends. Punjab Scheduled Caste and Backward Classes Reservation in Services. Punjab Scheduled Caste and Backward Classes Reservation in Services Act 2006. In short, it is called Punjab Act. What is the object of this act? The section 4 subsection 5 of the Punjab Act provided 50% of the vacancies of the Supreme Court reservation, scheduled caste reservation shall be offered on first preference to Balmikis. So 50% preferences will be given to Balmikis. It is one of the subcaste in SC community, and Mazhabi Sikh among the SCs. So when there is a scheduled caste under which there will be other subcaste, but this act gives preference, only 50% preference to Balmikis and Mazhabi Sikhs. Now who is aggrieved? The aggrieved is the other parties, those who fall under the scheduled caste. They have challenged the constitutional validity of section 4 subsection 5 of the act by giving, which gives preference, 50% preference to these people. It came up before the Punjab and Haryana High Court. What did they do? The honorable judges considered the constitutional validity of this particular provision, and they have relied upon one landmark judgment rendered by the Constitution Bench of the Honorable Supreme Court. Please note down, dear friends, this is very important case. E.V. Chinnaya. E.V. Chinnaya versus State of Andhra Pradesh. E.V. Chinnaya versus State of Andhra Pradesh. This case, this landmark judgment was reported in 2005. 2005, Volume 1 Supreme Court Cases, page number 394. 2005, Volume 1 Supreme Court Cases, page number 394. So, in this case, the Punjab and Haryana High Court has relied upon this Constitution Bench. In this case, what was held by the Honorable Supreme Court was, whatever the subcost mentioned in the scheduled cost is, they are homogeneous. They should be treated equally. There cannot be a subclassification within the scheduled cost. So, subclassification within the scheduled cost is impermissible. So, that was the judgment rendered by the Honorable Supreme Court. Exactly what is the exact finding? Let me read, dear friends. In essence, in Chinnaya, a constitution bench of the Supreme Court, 5 judges, held that subclassification amongst SCs, that is scheduled cost, by states is unconstitutional. There cannot be a subclassification within the scheduled cost, that is unconstitutional. Why it is unconstitutional? Reason is, number 1, scheduled cost constitute a homogeneous class. All are similarly placed, that is what they are saying. We are not able to see it is heterogeneous, it is homogeneous. When they are equally placed, where is the question of subclassification? Therefore, it is a homogeneous, number 1. Number 2, subclassifying them, if you are going to subclassify, then it is going to tinker, it is going to violate with the presidential list under Article 341 of the Constitution. Please note down, dear friends, 341 I will explain now. So, if the state is going to subclassify within the SCs, then it is going to violate Article 341 of the Constitution of India. That is second point. Third point is, the rationale of the 9-judge bench of Indra Sawhney versus Union of India. Indra Sawhney versus Union of India, which permitted subclassification for the other backward classes. So, they have not talked about the subclassification for SCs. Therefore, we are following the Indra Sawhney case. Right, dear friends? First one is homogeneous. Second is, if you are going to subclassify, you will be violating, tinkering with President's power, which is provided under Article 341 Clause 1. Third aspect is Indra Sawhney case, which provides for subclassification only for the other backward classes. There, yes, OBCs. Therefore, where is the question of SCs giving subclassification for SCs? Therefore, Chinnaya has held subclassification within SC is unconstitutional. So, this judgment was relied upon by the Punjab and Haryana High Court and held Section 4, Subsection 5 of the Punjab Act is unconstitutional. Now, the matter came up before the Honorable Supreme Court, before the 3 judges bench. Dear friends, very important. Each aspect is very important. How the procedure is. When the matter comes up before the 3 judges bench, the honorable judges wanted to revisit the correctness of Chinnaya case. 3 judges, because 5 judges judgment is binding on 3 judges. So, 3 judges cannot overrule it. Why? Because of doctrine of judicial discipline. Please, for AOR aspirants, they need to write doctrine of judicial discipline and doctrine of precedence. 5 judges bench binds on the 3 judges. Then master of the roster. Who is the competent authority to refer to the larger bench? The Chief Justice of India. Therefore, 3 judges bench has requested the Chief Justice of India to constitute appropriate bench. They have not pointed out what is the numerical strength. That will also tinkering with the master of the roster principle to constitute appropriate bench. Now the matter went to the Chief Justice. Honorable Chief Justice constituted 5 judges bench. Thereafter, 5 judges bench have found that no, this case has to be referred to the 7 judges bench. Then only they can check the correctness of E.V. Chinnaya's case. So the matter travelled to the 7 judges bench. So this is how the matter referred to the 7 judges bench. Now the most important provision, that is I refer to Article 341 Clause 1. What does it say? 341 Clause 1 empowers the President of India to notify which subcaste will fall under the scheduled caste. So President of India has the power to notify the caste which may fall under the scheduled caste. Article 341 Clause 2 empowers the Parliament to include any caste in the scheduled caste or exclude any scheduled caste. So they can do so. So when it is a power vested with the either with the President as well as with the Parliament, the state has got no competency. That is what one of the arguments were urged. So hope it is clear, dear friends. What was the facts? How the matter reached up to the 7 judges bench. Now what happened in the 7 judges bench? Let me tell you that decision of the Supreme Court. The 7 judge bench by a 6:1 majority held that it was permissible. Majority says it held it was permissible for states to subclassify SCs when providing reservations. So under scheduled caste, we can subclassify, that is constitutionally permissible. That is what the majority of the judgment says. All 6 judges concurring with this view. Chief Justice Dr. D.Y. Chandrachud Lordship has authored a plurality opinion for himself and for Justice Mishra. And other judges, Justice Gavai, Honorable Justice Mittal, Justice Vikram Nath, Honorable Justice Sharma, each authored a separate judgment concurring with the learned Chief Justice of India. So by holding that it is subclassification is permissible within the SC community. Who has given a dissenting opinion? Dissenting opinion given by Honorable Justice Bella M. Trivedi. Her ladyship has given a dissenting opinion. Now we have understood the decision also. So what was the major issue? Now we are moving on to the issue. Issue is Article 14. Article 14 of the Constitution of India provides equality. All should be treated equally. Equality before law and equal protection of law. How then these people, even SC community itself a reserved community, under which how are you classifying? Why are you giving a reservation to Balmikis? Therefore, it would amount to violation of Article 14. So this was one of the issue. Then they have considered about Indra Sawhney case also. Number 2. Number 3, Article 341. They have discussed about Article 341. Does it tinker with Article 341 Clause 1? Or does it violate Article 341 Clause 2? And by making reservation for subcaste, would it amount to violation of Article 15 and 16 of the Constitution of India? Article 15 says no discrimination. on the basis of any religion, race, sex, or place of birth. Article 16 says equality of opportunity in terms of public employment. Now, the state is coming forward by giving reservations. So, are you not discriminating on the basis of caste? But there are specific provisions are there. That is Article 15 Clause 4 and Article 16 Clause 4. So, those issues are considered. Thereafter, the issue was about the correctness of E.V. Chinnaya judgment. Yes, ultimately they are questioning the correctness of E.V. Chinnaya's judgment. So these were the collective issues where before the constitution bench, dear friends. Now let us understand what is the conclusion of our Honorable Chief Justice of India, and let me explain with reasons. So let me take you to, dear friends, page number 166. So I have a SEC reported, therefore I am referring to the page number of Supreme Court cases. Page number 166, conclusion. In view of the above discussion, the following are our conclusions. What is that conclusion? Article 14 of the Constitution permits subclassification of a clause which is not similarly situated for the purpose of the law. The court, while testing the validity of subclassification, must determine if the class is a homogeneous integrated clause for fulfilling the objective of the subclassification. If the clause is not integrated for the purpose, the clause can be further classified upon the fulfillment of the two-pronged intelligible differential standard. What does it mean? Article 14 says equality. But let us consider, dear friends, under the scheduled caste, these Valmikis and other Sikh community where they have given 50% preferences in government jobs, they were excluded. So according to the honorable judge, they have held that though there are many subcastes falls under the scheduled caste, but there is a lot of difference in terms of their representation in the government jobs. So these people, these subcaste Valmikis and the Sikh community, more specifically the name of the Sikh community is Mazhabi, right? Valmikis and Mazhabi Sikhs. So these two subcastes are being ignored. So therefore, how do you say that they are also fall under, they are also similarly placed? Some of them have become a creamy layer also in the SC community. These people are ignored. So you cannot say, though they may fall under scheduled caste, doesn't mean that they are homogeneous. There is a huge difference. Some of them are in the top floor, but community subcaste like Valmikis, they are in the basement. So it is a duty of the state to bring the people, those who are in the basement, bring it to the mainstream and give them the opportunity in the government jobs, services. Therefore, subclassification is permissible to ensure equality. See how beautifully they interpret. There is no equality among the subcaste in the SC community. Provide them the reservations, bring Valmikis to the government job, provide them the equality with that of other people, those who are advanced. See how beautifully they have interpreted. And how do you determine it? They have given the principles, dear friends. Let me take you there. Para 85, page 116. The question is, at page 116, para 85, when the constitution permits valid classification. Please note down, dear friends. Now we have said, now the target is subclassification is permissible. To support that, how the lordships are giving their reasons. First question I am asking to myself, when the Constitution of India permits valid classification, because here they have subclassified, when it permits. So the answer you will find at para 85. Let me read this, friends. This is very important. because they are discussing the principle of law. As a AOR trainees and AOR aspirants, we have to write this. Para 85. The Constitution permits valid classification if two conditions are fulfilled. Please note down, two conditions are to be fulfilled to satisfy that classification is permissible. What are those two conditions? First, there must be an intelligible differentia which distinguishes persons grouped together from others left out of the group. The phrase intelligible differentia means difference capable of being understood. Difference capable of being understood. That means what? Though Valmikis fall under the scheduled caste, but in their own eye, they are able to see the difference that they are not duly represented in government jobs. So, by looking at them, capable of being, we can understand that there is a huge difference. So, intelligible differentia is identified. Number two, the difference is capable of being understood when there is yardstick to differentiate the clause included and others excluded from the group. In the absence of the yardstick, the differentiation would be without a basis and hence unreasonable. What they are saying is there should be a difference, and how do you find out the difference? It should be on a rational basis. Based on the reasonable aspects, you have to subclassify. When there is no reason, then such subclassification is impermissible, right? So first, there should be a difference. Advanced group with other scheduled caste people, those who are not advanced. So in making the classification, the state is free to recognize degrees of harm. Though the classification need not be mathematical in precision, there must be some differences between the persons grouped and the persons left out, and the difference must be real and pertinent. The classification is unreasonable if there is little or no difference. So this is what about intelligible differentia is. There must be a huge difference among the subcaste falls within the scheduled caste. Number one. Number two, second condition is the differentia must have a rational relation to the object sought to be achieved by the law. That is, the basis of the classification must have a nexus with the object of the classification. Here, what is the object? Object of the Punjab Act is to provide social justice. Valmikis are not duly represented in government jobs. Therefore, the object of the act is to give preference, 50% preference to those subcaste. Therefore, they can be employed in the government jobs. So, subclassification is made. There is a difference. To remove the difference, 50% reservation, preferences are given. Therefore, it qualifies two conditions. Therefore, subclassification is permissible and it does not violate Article 14. This is the first question, dear friends. Second aspect is at page 120, para 93. And one more paragraph also, para 86, beautifully they have said, subclassification as a facet of equality. See, other side is arguing you are subclassifying, therefore it violates Article 14. But Lordship, they are saying subclassification is a facet of equality. Because from the eyes of the justice, they are saying that injustice is being done to Valmikis. Therefore, give preference, give them reservation. Therefore, those are economically, socially backward, they will also be appointed in the government jobs by giving preferences, reservations. Therefore, subclassification is a facet of equality. Subclassification as a facet of equality. Now, the next para is page 120. Please note down. Page 120, para 93. So, what is the question that we have to ask here is, what is the test? Please write down the question, dear friends. Page number 120, para number 93. What is the test for the court to determine the validity of subclassification of a clause. So what is the test for a court to determine the validity of subclassification of a clause? In this case, Valmiki's or the subcost of a scheduled cost. So have whether the Punjab Act has done it rightly or wrongly. What is the test? Dear friends, the Lordships has given the principles here by discussing many numerous landmark judgments. So we are not seeing the root, we are going to see only the fruit of it. So please focus. The test that the court must follow to determine the validity of the subclassification of a clause is as follows. A, whether, you have to ask yourself this question as a court, whether the clause is homogeneous or similarly situated for the purpose of specific law. You have to ask this question, whether all those subcosts provided under the scheduled cost, do they constitute homogeneous or not? Are they similarly placed or not? That is the first question. If the answer to A above is in the affirmative, if the answer is yes, all are homogeneous, all are on the same pedestal, no differences at all, then there is no question for subclassification. Subclassification is not required. But if the answer to A above is in negative, if we say that other subcasts are duly represented in government jobs, but Valmikis are left out, therefore, though they fall under scheduled cost, but still there are differences. They are not homogeneous, they are heterogeneous. So there is an ocean of difference among the subcaste itself. If the answer is like that, then the class can be subclassified upon the fulfillment of the following standard. So when there is a difference, then we can subclassify. But to subclassify, we have to fulfill twin conditions, that is intelligible differentia. There must be a yardstick or intelligible differentia further classifying the clause, and the yardstick must have a rational nexus with the object of the statute. So this is the twin test in order to make a constitutional permissible for subclassification.